Hey, good afternoon, everyone. This is Mitch Piper, National Membership Director here at ASTPS, and I guess it hasn't been too long since we were all together. I guess it was only last week, but so we got another great presentation for you today. Roger Nemeth, who's the founder of Tax Help Software, and so just a couple of housekeeping things before we get started. The handouts are, if you're in the GoToWebinar panel, you can download those, right? You can just expand that panel and you can download all three of the handouts. The CE, you have to be in here for 50 minutes. We're going to ask 3 polling questions. You have to answer all 3. We're going to leave them up for a minute, and I will announce those. And then probably on Friday, everybody, make sure everybody's listening here. I'm going to send them out on Friday, I promise. So you don't have to email me or anything about them. So you should get an email notification for those. Questions, we're going to try to hold all the questions to the end. Roger said that he had quite a bit of material to go through. We also have Jeff Long on here, who's going to be speaking at our spring conference. He was a former revenue officer. He's actually going to talk a little bit about his presentation later on after the technical part's over, but he's going to be answering some questions in the chat, and then he's going to flag a few for Roger to answer towards the end. And then, like I mentioned, we're going to be talking, Larry Lawler is going to get on at the end, and we're going to talk a little bit about the spring conference and what you guys can expect if you wanted to attend that. But I won't take up any more of the time. Roger, are you all set?
Yep, I'm ready to go. Can you hear me?
Yeah, I can hear you great. Get started.
All right, so today's presentation I've wanted to do for a long time. It's called Tax Resolution Case Prep. And ignore the learn about 3 statutes. I stole this from another presentation. I'm just catching that that's there now. But what this course is going to do is, well, I guess the introductions, most everybody knows who I am at ASTPS. Started managing tax franchises in 2006, developed audit detective in 2010, qualified as an NTPI fellow in 2015, worked as the programmer for the largest resolution company integrating automated transcript systems into workflow programs, assisted in the downloading and research of over 30 million transcripts while with them. And also to date, our software has been used to download just under 1/5 of a billion transcripts. So I used Mitch's favorite picture. It's me back when I was a cop and we found a big old grow house underneath a crawl space. So
I was glad to see that one back in there.
Yeah, I went professional, but Mitch does love that picture. So, which, you know, funny enough, in most states that's no longer a crime, and you know, maybe one of these days we'll do a marijuana class and tax implications. So, all right, back to this course. So this course is a best practice course on how to do a proper tax resolution client intake. The target audience should have a basic knowledge of IRS transcripts and tax resolution work. I'm going to talk about things like CDPs, but understand this. This class does not cover how to do a CDP. It'll talk about the CDP deadline, but you know, a CDP in and of itself is going to be a separate, at least 1-hour class. This is kind of the workflow of how to bring a client in. So one of the things that I've been kind of playing around with in the off season while y'all were busy working was I've started to do these workflows. All right, let's see if I can bring it over here. So this is one of your handouts. So you're going to see a lot of this starting to come from us in the classes that we do. And also we're going to start pushing this out for those of you that have the program. It'll be like how to set up, how to do transcript requests, kind of some of the simpler things out there. But what I found is people like that visual workflow. And I'd love to have some feedback, especially near the end of the presentation, of having a workflow along with the PowerPoint if that's a if it provides any value. So, all right, so the 2 handouts are the flow chart. I also added IRS publication 594. It's just the IRS collection process. It's a very good document. You'd be surprised how many people come to these things that have never read it cover to cover. It's 8 pages. It'll probably take you a little less than an hour to read through it. It's a lot of material, but it is the IRS collections process. So it's just a real good background handout, especially for those that are just looking to get into tax resolution, or maybe don't do it a lot and just when the cases pop up. All right, so fundamentals. Whoops, back it up here. Oh, I also wanted to let everybody know. So 30 minutes before the presentation, my internet dropped out for about 10 minutes. If I drop off, Mitch has the presentation, Jeff will pick up, and I will call on a landline. So we may have just a slight delay if MediaCom decides on a bright sunny day in Florida, they're going to drop out again. So, all right, basic fundamentals of collection work. Remember, your time has value. Although that simple statement is there, you would be amazed at how many people don't charge for what they do in tax resolution. Okay, so resolution is a function of three primary things: the cost of the lead, the man hours to work the case, and the amount charged. If you look at that pyramid, that's going to define whether or not you're going to make money or lose money on a case. Right? The more time you spend talking with your client, the less money you make. And a lot of that mistake ends up being made on the front end. Little tip for everybody out there: the big resolution firms, for the most part, don't have tax people answering the phones. They have salespeople. People just want to be reassured that you're going to take care of it. Things are going to be fine. I would stay away from pennies on the dollar, but they just kind of want general affirmation of everything will be good, everything will be fine. Us tax people tend to get in the weeds, start talking about things that they don't understand. So little tip from me: early on in the process, don't get so much into the hows. You're selling yourself to be the representative, and also you're looking for, what they're looking for from an outcome. Okay. Client initial meeting. All right, so the first time that you sit down with a client, I recommend get a 2848 and state POAs if necessary, signed to cover all years at issue at a minimum. Or at a minimum recommended back to 1998. I used to recommend going back to 1990. If you're using software to go ahead and get the transcripts, there's no harm or foul going back to 1990, but be advised that FTA is now restricted to 2001 and newer, but you would need the 3 prior years to 2001 to check on FTA, okay? Those of you that have heard me speak on other things might say, what about an 8821? You could do an 8821 here. However, you'd have to have the client come back in and sign the 2848 or have them sign both documents. If you're fairly certain you're looking at doing representation, I would get the POA signed here. If the client calls you in 4 or 5 days and says, you're not for me, I'm going with somebody else, just immediately refax in the POA with a withdrawal at the top, and it'd probably be withdrawn before they even get it in the CAF system. So if it's resolution work, I would stick just to the 2848. All right. I do have samples on our website at taxhelpsoftware.com. I've got to add the links back this afternoon. We did some updating on the website, and those links to the templated 8821 and 2848 came down. Something new with the 2848s and 8821s, both in the software and on the website, we've expanded the font to as big as you can get on an Adobe PDF, and it's supposed to shrink if you happen to get a really long entry. So that's kind of been a long requested something out there, because we've been using the IRS font. It's an 8 font by default, and people have trouble reading them at the IRS. All right. So also make sure to ask your client about businesses and request civil penalties and separate assessments for individuals to avoid surprises later. When I finally got my EA license, the very first client I sat down with, and I had already created most of the program, I had seen transcripts. She came in, said, I owe about $30,000. Pulled her account transcript and it said 0. I said, you owe nothing. You are good to go. They wrote it off. So she comes in 3 weeks later with a letter saying, see, I told you I owed $30,000, and it was an IRS letter saying she owed $30,000 and how would she like to pay that? So I called the IRS up and said, where'd the $30,000 come from? I'm looking at the account transcript, it says 0. That is how I learned my life lesson about separate assessments. Her and her husband had divorced. He had filed bankruptcy. It split everything up. They did the mirrored accounts. So my recommendation is to always ask for civil penalties and separate assessments. Probably less than 3% of the transcripts I see, people actually have civil penalties, but don't get surprised. Pull them on the front end. You won't get surprised on the back end. Okay. Also, ask about state issues and get appropriate POA for each state municipality. Sometimes the states will honor the federal POA, but it's best to just go to their website, see what their process is, get it filled out, and get it signed. Okay. And if you're confident you'll be representing the client, ask them to start gathering their financial records. And if you're really confident, I talk about it later on, I would even have them go into myfreecreditreport.com while they're in the office and pull at least one credit report for you. That way you can start working on the financials very early on. The biggest bottleneck in tax resolution work is getting information from your clients. If your client walked in the first day with all the documentation you needed to do a 433, most resolutions could probably be knocked out in less than 5 days or less. Now, granted, you're going to wait a time for the IRS to evaluate. That can be much longer. But there is usually, especially when you're doing collections work, a very defined process, and what can kill you on this is waiting to ask for documents until later on. Okay. And it's not wanting to go to the next slide. There we go. All right, so now here's a big one: to charge or not to charge. Some tax pros charge for the initial interview and some charge for the transcript analysis. Most tax pros do this for free, but it does have value. Charging for the initial IRS account analysis can be a good indicator if the client is just shopping or fishing for free information or if they are committed. Fees that I've seen have ranged from $50 to $1,500 or more for a tax resolution case. I never was in a practice where I could get away with charging $1,500, but I do know of CPA firms out there that are interviewing people with big tax issues that are doing a $1,500, they call it an account research fee, to do the research at the IRS. So depends on your practice. I do like charging something because it shows that the client is prepared to pay. Some people will charge a fee and say, if you decide to go with me, I'll deduct it off the actual resolution fee that I'm going to quote you. So just kind of a little tip there. There is a ton of value in identifying what somebody's tax problem and possible outcome is. Be careful of the shoppers that come in and basically want you to tell them, well, if I were you, I would just go do a streamlined installment agreement by going to the website. You're probably not going to see that person again. So again, salespeople versus tax people at the big res firms, that's for a reason. Initial interview red flags. So as you're sitting down talking with somebody, be aware of the things that you want to listen out for. If the client indicates any of the following circumstances exist, the rest of the process may need to be accelerated or terminated. Example, if the client is being levied, the tax pro does not want to wait 3 to 5 business days for a 2848 to be accepted by the CAF unit to get transcripts. All right. Now, in some cases, you will want to wait to contact collections, but I was talking it over with my dad that does a lot of resolution, and he said he usually likes to wait, get his ducks in a row before he contacts collections if the notice of intent to levy has already been delivered. But then he went on to make the comment, well, except I had one recently where they got levied before I actually called them. So I would prefer to wait, but at the same time, there's nothing like a client getting levied 4 days after they signed an engagement letter with you, and all of a sudden their bank account's drained. So it's that balancing act of jumping in too early or waiting too long. So, and I've got some tips coming up on that. Are there any indicators the case is criminal? Now understand.
Hey,
yes, go ahead.
Roger, you're breaking up.
Uh-oh. All right, let's give it just a minute. And I'll stay on the slide. All right.
Oh, there you go.
Oh, am I back?
I think Mitch was the one breaking up. Roger
Oh.
sounded good to me.
Oh,
Okay.
that could be too. My bad. Sorry. All right. Thanks, everyone. Sorry about that.
All right. Thanks, Mitch. We all appreciate it. So, all right. So anyways, I'm going to get going. And if audio is a problem for me or anybody else, just let us know in the message box. Thanks. All right. So first one, is the case criminal? Very few cases go to criminal, but you have to realize it's a possibility and some of the things that you're going to want to watch out for. Typically, I don't think criminal. However, having a lot of users that use our product, I had one new person that ended up getting a couple of doctors, and they ended up being $1 million non-filing cases, and they were criminal. And this guy was just getting started, bought the software, and when I saw the case, first thing I said was, I've got some people I can refer you to help you with these, because it was well beyond their capabilities. And both of them ended up going criminal. So that's why I bring it up. You know, are you going to get hit by lightning just because you visit the state of Florida? No, but be advised, if a thunderstorm's coming, you might want to head inside. So just for that reason, it's got to be discussed, but understand the odds are very low. Are there any indicators case is criminal? We'll talk about that in a second. is the client actively being levied or garnished? And if you say, are you being levied or garnished, they'll probably say, no, I'm not. And then later on go on to say, well, but my money's going from my bank to the IRS, or my paycheck's half of what it should be. They may not understand the words that you're using, so you may want to gauge who you're talking to and ask very specific questions. Has the client received or ignored any certified letters from the IRS? And I say ignored because have you gotten any notices from the post office that you might have something waiting for you? What I find is no good news is ever delivered with a certified letter. So, and then the next one is the client an audit or exam? Again, they may be and have no clue. So, all right, how to acquire IRS transcripts expeditiously. All right, so when you've got software like THS, getting transcripts is fantastic. However, there's a 3 to 5 day delay at a minimum, and depending on the time of year, it can go upwards of 2 weeks. All right, so here are the options to get transcripts on those times when you really need to get your hands on them quick. First, you can use IRS Get Transcripts. We're actually coding into our software right now a little app where your user would be able to go in with their Get Transcript username and password, download the PDF transcripts from Get Transcripts, and you'll be able to process them into a basic report. It's not going to be a full report, but it will give you all the things you need to evaluate the client for tax resolution. Are they in any trouble? The main dashboards that you're used to, that's what we're going to extract out of those transcripts. So looking to do that sometime before the end of the summer. Priority practitioner hotline. I always get people that call up and go, I don't have 2 hours. Or I'll get somebody on a Friday that says, I have to get the call done. All right, I don't have any part of NQ, but it's a great service. If I was still actively representing people, I would buy it in a heartbeat. NQ, you pay for the service. I don't know how much it is. He's got a website, but it lets you contact the IRS within 3 minutes. And even if you're on the East Coast, it will let you contact till 6 o'clock on the West Coast time. It's a great tool. So that's your other option. And if you only need it on that one Friday, it's $4.45. It only takes a minute to sign up for the trial, and he's got a trial. So yeah, just try it on the Friday night. And then you can also go to an IRS office. However, some of them now require appointments. So just be aware if you're one of those people that has been near an IRS office that's been problematic with them trying to restrict what services you can do without an appointment at the IRS office. We are meeting with the IRS later this month and are in a focus group for instant transcript access through e-services. I hope to do, I don't know, at least for our users, we'll be sending out emails. If you're not a user, you can still, if you do a trial, get on our mailing list and you'll get all the mailers, which are updates on e-services. But we hope to have some information on what the IRS is currently working on to give e-service users instant access to their clients' transcripts. The IRS understands it's a problem and they're looking to solve it. All right, so is the case criminal? And this will be during the verbal interview. If the taxpayer is a serial non, yes.
Hey, sorry, I meant to interrupt you a second ago. I'm going to do the first polling question.
Okay, first polling question.
All right. And sorry about that, guys. I thought it must have been something wrong with our phones here. It sounded like Roger was breaking up. So, but glad to hear that it was just me. But we'll give you guys about 30 more seconds to answer this, and then we're going to move on.
Yep. And for those of you on the flow chart, we are on pretty much the first decision tree. So we're right after initial verbal client interview. And is it criminal? And then also, if you'll notice on the flow chart, we've got 3 things that we asked during the oral interview at the beginning, and then we have different questions we ask after we have the transcripts. And those we're not even asking the clients, we're asking the IRS through the transcripts themselves. Because remember, the more you talk to your client, the less money you make.
Mm-hmm. Yeah, and you guys got about 10 more seconds, and I'll just throw in there too, one of the first slides you were talking about not speaking directly to the calls when they're coming in. We don't do that actually anymore at our CPA firm, and it's helped out tremendously because as soon as you put a practitioner on the phone, you're automatically going to start trying to diagnose problems and things like that, and you're just better off just get them to come in and make an appointment. So I definitely agree to that. But all right. That is it. If you want to move on, Roger.
Yep, back to it. So is case criminal? If taxpayer is a serial non-filer and tax debt is over $100,000, the client may want to consult a tax attorney. by that, here's my recommendation. And this slide right here is more for your newbies, people that have been doing this for a while. You have your own internal, the spidey senses. Spider-Man has spidey senses. We all have our spidey senses of when we think something might possibly have that option. And the reason you want to identify criminal early on is you may want to refer it to a tax attorney and get under a COVAL letter. If not, you could be subject to testifying against your client. So the way I usually cover this with a client when I was practicing actively would say, look, you owe a lot of money. You're a serial non-filer. Technically, that's a violation of the law, but most times the IRS just wants you to get compliant and pay for the tax. But I'm making you aware of this because any conversation we have after this, and I prepare your returns and things like that, not everything can be privileged, all right? So with that being said, I'm going to give you the opportunity, if you wanted to go that extra step of getting a tax attorney, I can do the referral. If not, we can go on from here. By doing that, I've now noted in their file that I told them they were technically in violation of federal law and gave them the opportunity to get a tax attorney to kind of protect some privilege in that. That way, later on, if it goes criminal and they want to come back to you and say that, well, you told them how you prepared the return, now you're in with that. And as far as privilege goes in tax returns, this class isn't going to go into that. We could talk about that for 2 hours, but just understand that this point in the tree, as early as possible, if they have a business card from IRS that says special agent, just be aware that that's when you would want to kick this in. So has the client been contacted by IRS CID? Have people with guns and badges visited? One thing somebody told me about IRS CID agents is they always travel in twos. So keep that in mind. Has anyone from the IRS read the client their Miranda rights? Okay, that's a big one. Do they have a business card from a special agent? One of the other ones somebody led me on to is the RO acting suspicious and evasive or ignoring calls? Problem is, don't they all be evasive and ignore calls until they need something? But again, that's where the spidey senses come in, and it comes with experience. So for new people, just understand you've had a basic conversation if they're in the criteria I gave you, and just note in the file that you explained to them it was a violation of federal law and they opted not to retain tax counsel at that time. If necessary, obtain COVAL letter and proceed at attorney's direction. Okay. Remember to document if you advise the client of the possibility of it being criminal. The decision to retain counsel should be theirs. The decision to take them as a client is yours. With that being said, so if somebody comes in and they're also telling you things that aren't true, a variety of things, remember, you don't have to take them on as a client. So nobody's ever regretted not hiring somebody, but I know a lot of people that have regretted bringing somebody into their practice. So
Roger,
next one, yes.
Could I just make one little point here? This is Jeff.
Absolutely.
Don't forget that as an enrolled agent or a CPA, we do not have full-on attorney-client privilege. We do have accountant-client privilege. But if the case goes criminal, you'll be testifying against your client. That's a really big reason not to take that client on, is that we don't know what criminal investigation division is doing. We're not entirely sure what case is going to go criminal. So Roger's point's well made. Hopefully you have some Spider-Man senses. You get that little tingle down your back, or you're like, wow, this guy hasn't filed for 20 years and he drives a Lambo. That's not so good. So I would recommend you have at least one tax attorney that you can trust that knows what they're doing. If you get a client, don't take any documentation from them at all. You've got to send them to the attorney. That's called a COVAL letter. It's a COVAL arrangement. The client is the attorney actually allows the client to hire them, and then you're kind of a subcontractor. So be careful with that.
Yeah, and if you're a newbie and a case is going to go criminal, definitely because the tax attorney will help you work the case in most cases. If you don't know one, call me. I'll figure out where you live and I'll get you a good referral. I don't charge for that. I don't get any money on the back or the front end on any of that. I mean, if you call me and say help, I'll tell you who to go to. But just leave it out there as an option. So is collections active? Has the client already been levied? Are the client's wages being garnished already? Has the client received or ignored any certified letters? And again, nothing's worse than having a new client get levied before you're able to review the transcripts. All right, so Jeff turned me on to this one. The original presentation said, if they're in levy, contact collections immediately to find out what's needed to start the resolution to stop that surprise levy, okay? But I added this slide just to give you the option. So should I contact collections immediately or wait? If your client is in active collections, the IRS can begin forced collections at any time. The two schools of thought are as follows. Contact collections immediately in order to assess what they need to enter a resolution. This may accelerate some deadlines and force the case to move along faster. Wait until your analysis is complete, so when you contact collections, you're prepared to negotiate based on your client's circumstances. Problem with waiting is that the IRS could issue a levy or garnishment. Nothing like having a new client again that's levied just after engaging your services. But here's where you're going to want to look at it. If the notice of intent to levy went out 14 months ago and no action's been taken, I would take the 2 or 3 weeks to get prepared and call them. If that notice of intent to levy just went in and they owe $300,000, now I'm going to start debating it a little bit. Okay. Of course, I'll be waiting for them to get back from the tax attorney if they owe $300,000. Little joke there, but
and
anyways,
Roger, let me make one point there. So if the client received either the LT11 or the letter 1058, so those are the two certified letters, final demand and notice for payment, or basically your rights to CDP, we're going to do nasty things to you now. And then that just drops to the wayside, and particularly for ACS, the LT11, which is the final demand and notice from ACS, a lot of those do go to the wayside. That's just a warning that never gets acted on. So there's 180 days per the IRM, the Internal Revenue Manual, before IRS has to kind of give a refresher. IRS used to send out a true refresher letter. More and more, they don't do that. Often the refresher is just a call that says, hey, we're back on your case and we're going to start doing nasty things to you. Levy, lien, seizure. Okay. So be aware that after that 180 days, the IRS needs to take some affirmative step, but more and more they're just, maybe the revenue officer, if it's in the field, is going to go out and knock on their door, leave the call back. That's all they have to do. They have to attempt. They don't actually have to talk to the taxpayer. So keep that 180-day time frame in mind after a LT11 or 1058.
Good point. And I think most of the time you're good with the week. And even if they do the levy, unless your client just got a ton of money sitting around, we'll address that in a minute if they've already taken it. All right, so now here's the new old IRS policy. All right, it has been on the books for a while, but it appears recently the IRS is enforcing this. If a tax pro or the taxpayer contacts the IRS for routine matters like getting transcripts or a CSED, the person is transferred from the practitioner hotline to collections or the RO. Presumably, this is being done to encourage communication to resolve the matter with the people in charge of the case. And I've seen this on message boards. I've had users call up and ask about it. The biggest rumor going around right now that I've heard is you can't get transcripts electronically if the case is in collections. It's not true as far as I can tell. Everybody that's called up, it's either been the CAF hadn't been processed yet and they got them in a very short time later. The other thing out there is the IRS never released the 2017 wage and income transcripts yet. It's never gone the entire tax season without pushing out wage and income transcripts. Presumably they did it to reduce fraud. I've got an indicator. It's just kind of an informal channel that we've got that the IRS should release 2017 wage and income transcripts May 7th. So hopefully in about a week or so, they'll start having the wage and incomes become available. My understanding is they did it because the mortgage transcript providers had third-party bad actors that were just paying them to pull transcripts on people that were not them. And then they were getting the wage and incomes and filing bogus tax returns. So the weakness in the system, again, wasn't the tax people. It was these third-party mortgage people that were the weak point in the system. But yet, keep this in mind about mortgage, and I'm on my soapbox. They can get a 4506 e-signed, and they have their own special CAF unit that processes their 4506Ts. So it's kind of my little pet peeve that they get a little better privilege and they're a bigger cause of the problem than we are. So is client under exam or audit? Although the client should know this, you may be surprised or not at the client's response. Remember, if the client ignores all communications, the audit usually is completed by the IRS and not in the client's favor. This can be difficult to determine in the initial interview, but it is worth asking. The transcript will have more specific information. Okay. Once the initial interview is completed, so the verbal's over, I would fax the 2848, or if you want, the 8821 to the CAF unit if not already submitted. Obtain and analyze transcripts as soon as they are available. To analyze transcripts, you can either create your own spreadsheets or use commercially available software. I could have done this whole presentation just based on our software, but there's some CE, CP requirements on product demos. So there is some material in here. It's the most material I can get in and still issue the CPE and CE credits. And that's coming up here shortly. All right, so now, is the case criminal from transcripts? The other question I always get is, can you tell if there is an RO from the transcripts? And the answer to both is no. Unfortunately, I've not found a way to detect criminal investigations from the account transcripts. The best advice is to review the set of circumstances after the initial client interview and transcript analysis. Serial non-filers with debt over 100K is usually when I would start thinking criminal investigation is a possibility. This does not mean a client who owes 105,000 and has not filed in 6 years is being investigated, just they might be. IRS CAD investigations have been conducted on cases under 100,000. IRS criminal cases are extremely rare, but tax pros need to be aware of them. Okay. All right, so here's a page out of the report, but also the reason it's in the presentation is every resolution firm and people that do a lot of resolution, whether you use a paid product or not, they have a spreadsheet that looks very, very, very similar to what I'm showing you right now. So for demo purposes, we're showing ours, but be advised, some people prefer to do it by hand. So in this case, here's a serial non-filer. All right. No returns filed since 2012. And also the balance on the previous years is $189,000. So those two things at the very least, advise the client, hey, it's a possibility, not to scare you, but it's out there, and I document it in the file that I gave them the option at that point. So I'm protected. And at the end of the day, that's what's most important. Important to protect yourself first, your client second. And if you're protecting yourself first, you are protecting your client as well. Criminal indicator on a Mod A transcript. So the Mod A transcript can show the presence of a criminal investigation. That's why they're not available electronically. They also have things on there, and I forget the exact wording, but it basically means, is taxpayer possibly a threat? And Jeff, do you remember the moniker for that?
Yeah, that's potentially
yeah, PDT, potentially dangerous taxpayer.
Taxpayer, PDT. Yeah, and that's supposed to be redacted as well. Oftentimes that'll get through. You'll almost never see that, but I had one last year, and essentially what that is the IRS has either been threatened by this person, or the revenue officer or somebody, an employee in IRS, believes that that person is a threat either to themselves or other people. They'll put PDT on there. That means that that is one of those situations where you'll actually see a TIGTA, Treasury Inspector General person come along, and maybe if they're bringing you into the office, typically they want to bring that PDT taxpayer into an office, and there'll be a TIGTA guy with a gun standing there, not criminal investigation, but they got their gun ready just in case. So if you've got a PDT taxpayer, the only way you're going to know that is when the revenue officer says, we're going to have some visitors with us, and that person's going to have a gun. So
yeah,
enjoy that client.
This is Agent Bob, and he's from the government, and he's here to help. So now some people have given me some tricks here. I don't know if they work, because this is kind of one of those that's hard. But what they do when you request a Mod A is they redact out the PDT and the criminal investigation things. So I've had people recently tell me those that can actually get Mod A's. So I have some people that get them every time they call, and other people, even former revenue officers, they can never get them. So I don't know why some get them, some don't. You can always do the FOIA, but if you get one and it's not redacted and you don't see CI or PDT on it, more than likely they're not being criminally investigated. So we are working on a class on Mod A's. The problem is getting enough source material and somebody that actually knows how to read them. Jeff's got some background in it, and some other users have volunteered. So that's one of the future courses we're looking at doing with ASTPS, possibly as a Mod A class. And that one will just be a matter of, once we get enough material, I'd love to do that class. I do not have any examples of what the indicator looks like, because they're redacted on the ones that I have seen. I don't have copies of any of the ones that people have provided with the redaction. Again, if you get the Mod A and nothing's redacted and you don't see the CI, they're both supposed to show up in the upper right-hand corner, but other than that, I really can't explain where they might be. So, all right, now from the transcript, is client in active collections? check the transcripts for years with a balance. For each year with a balance, do look for TC 971 collection due process notice of intent to levy issued. Look through the transactions to see if the client is in a resolution. CNC, pending IA, established IA, any of the resolutions. Also, double check to make sure the resolution has not been reversed or denied. AuditDetective.com, which is kind of a knowledge website we have separate from Tax Help Software, it has a list of all the IRS transaction codes plus all their definitions next to it. And yes, it is available on the IRS website. We just lay it out with all the different definitions in one table. It makes it a little bit easier. It's what I personally use when I'm researching to do logic queries with the software, and I make that available to everybody. All right, so a levy release. What if your client is in active collections and the IRS already levied your client? You can apply to have the levy released. So a lot of new people don't know this. They figure once the levies happen, you're done. So the IRS is required to release the levy if it determines that you paid the amount you owe, the period for collections ended prior to the levy being issued, releasing the levy will help you pay your taxes, you enter into an installment agreement and the terms of the agreement don't allow for the levy to continue. The levy creates an economic hardship, meaning the IRS has determined the levy prevents you from meeting basic reasonable living expenses, or value of the property is more than the amount owed, and releasing the levy will not hinder your ability to collect the amount owed. Second to last is the one I've seen people with the most success with, and that's the levy creates an economic hardship. If they drain a bank account, who doesn't it do? An economic hardship. So just be advised, just because the levy's already been hit doesn't mean that there's not a window where you can go into. And again, this class is not on levy releases, so we're not going to go down the rabbit hole. Jeff would be a good one to do a class on that. And again, you could probably spend an hour just on levy and lien releases, probably a full day actually. So now on the flow chart, I combined the CDP one into also the NOD appeal. They're kind of similar, but they're different, but you kind of want to look for them at the same time. So first we're going to cover CDP. Is the CDP needed? The taxpayer is entitled to a CDP hearing before appeals if the IRS sends the taxpayer a notice concerning a proposed levy, a notice of levy, or a notice of federal tax lien. If such notice states the taxpayers have the right to request a CDP hearing, CDP procedure. You have 30 days to request a CDP hearing. Complete Form 12153, request for a due process or equivalent hearing. It is important to identify all the reasons for any disagreement you have. The completed Form 12153 should be sent to the same address that is shown on your CDP notice. If your request is timely made within 30 days, you'll be entitled to an appeals hearing and to seek judicial review of that hearing with the tax court. If your request is timely, IRS levy action is generally suspended against you for tax periods you appealed. With that being said, if you end up doing an equivalent hearing, I've never heard of anybody getting levied while you're in the equivalent hearing. It's kind of one of those secret tricks, gray area kind of things that resolution people use, is that it's better to do the equivalent hearing if you don't plan on going to tax court. So just kind of keep that in mind. And again, we could cover CDP and NOD appeals all day long, but just for this presentation, just be aware that sometimes it's better to be late and file the equivalency hearing. Okay. If your request is not timely, you're still entitled to request the equivalent hearing with appeals within the 1-year period described in 12153. However, if you still disagree with the appeals decision in the equivalent hearing, you have no right to judicial review, okay, by the tax court. All right, so the equivalency hearing, it's a CDB tolls the CSED date and 2 of the bankruptcy discharge rule dates. One of the presentations we're going to be doing with ASTPS, it'll probably be the next tax one we do. It's going to be how to calculate the bankruptcy discharge dates for tax professionals. You're not allowed to give the legal advice, but you are allowed to do the calculations and then assist with bankruptcy attorneys. Anybody doing tax resolution, I recommend you reach out to local bankruptcy attorneys as a source of leads and also consultations for them. When people file bankruptcy, they also have to get current on their taxes. So it's a very good relationship. And I think that class will help people. If you can call these bankruptcy attorneys up and let them know you can do bankruptcy calculations with them, that's going to add value to them referring people to you. All right. So the equivalent hearing does not toll the CSED or the bankruptcy, but it's a very similar process. Again, it doesn't have the appeal rights. And here's the funny part. So I had somebody file 32 days after the notice date, and they got a CDP hearing. They had to go to the IRS and tell them, no, I didn't file it timely. You need to back it out into an equivalent hearing. So I would always wait maybe an additional 10 days and file it if that's what you're wanting to do. I've been to a lot of classes on CDPs, and I understand when you get in the real complex cases, you may want to go down that path. I may work a case, or hear if Jeff Long would do a case where he may go into a CDP. But I asked my stepmom, and I ask a lot of people, when have you specifically used CDPs? So Mary Brody in Atlanta, I like her answer the best. And I hope this helps those that try to get their head around CDPs. Like, why does anybody want to follow CDP? A lot of people don't have success with them. She says, basically, if you're dealing with a butthead at the IRS that won't listen to you, you do the CDP in an effort to talk to a more reasonable person. And I've just always liked that explanation. So,
Roger, can I step in just for a minute here? I've got a real personal heartache with CDP and CAP, collection appeals process, even worse, but CDP, because you really have to understand what your goal is when you ask for CDP. You have to understand the timeliness, the 30-day rule. But more than that, what are you preserving in a CDP that you don't get an equivalent hearing? And generally, what I say to my client is, unless you're absolutely certain that you want to have the right to go into tax court, which in collections matter, not exam, but in collections matter, the most that the tax court judge is going to rule, if you get a ruling in your favor at all, that the IRS was capricious, that they exceeded their legal right. The best you get is an IRS do-over. They send it back to the same IRS boneheads that made the decision to levy or lien your client to begin with. So I have a discussion with all my clients. Do you want your personal and tax matters in the public domain? Because that's what happens once your case is actually heard by a tax court judge. And is it good for you that the best we get is a do-over from the IRS? And oh, by the way, would you like to pay $20,000 to have the right to have a decent tax attorney take your case into tax court? I get them to affirmatively email me that says, I understand the situation and I do not want to save my tax court right. Now I'm in equivalent hearing. I have yet to have the IRS levy or lien while I'm under an equivalent hearing. They can do so, but generally they don't. And I think if they did, then that may be another idea that maybe you've got a criminal case. That's all I got on that, Rob.
Yep, sounds good. And that's what I like is, I've been to a lot of classes on CDPs and CAPs, and nobody ever covers when would you really want to go into them? They talk about them, and you're definitely not going to do them on every case. Mitch, you need to do another polling question?
Yeah, I was just waiting for, if you want me, I can do it right now.
Okay, yeah, go ahead.
Just didn't want to interrupt you.
Yeah, we're probably going to go a little bit long, everybody, but I think the material's, pretty good. It's been good having Jeff on because he obviously has so much to offer, and especially in this part of the process. All right, and just let me know when you want me to get going. Yeah, and this is the first time I've done this class. I was still adding material last night to this class. I think if we ended up doing this class again, we'd actually make it at least an hour and a half, maybe even 2 hours. Some of this is also going to be in our user conference coming up in Atlanta for those going to the ASTPS spring conference in Atlanta. So, and Mitch, just let me know when you're ready for us to go on.
Hey, Roger, it's Larry.
Hey, Larry.
How you doing? I just wanted to throw out there while you're talking about running a little bit long. If people want to hang on for a few more minutes, I've had several phone calls from people wanting to know the content of the spring conference. And I have just got some outline of some notes that I can tell them what the different speakers are going to be talking about, that sort of thing. So I put together a little presentation we can do for a few minutes at the end too.
Okay.
And maybe even having Jeff Long on here because Jeff's going to be speaking at that conference. We might even let him describe his own if he wants to, or if not, I'll do it. But I just thought I'd mention that to you while you were in the polling question. So,
okay, yeah, definitely.
I'm going to mute myself, shut up, and get out of here.
All right, and Mitch, I'm gonna go ahead and go. We've got
Yeah, you're all
18
set.
slides, and we've got about 15 more minutes. So, so is the NOD appeal needed? Check the transcript for a TC 494, final notice before taxes determined for you by IRS, the statutory notice of deficiency. If it has not already been reversed by a TC 495, there's a 90-day window to file an appeal. Not all NODs show up on account transcripts, but keep this in mind. I've had calls from people that say, hey, the software didn't detect an NOD, okay? In those cases that I've been made aware of, if the NOD wasn't on the transcript, they FOIA'd and a notice of deficiency was never actually sent. Or let me rephrase that. The IRS had no proof an NOD was sent. So if the NOD doesn't show up on the transcript, I can't affirmatively say that no NOD has been sent. And I also can't say that one has been sent, but a FOIA request may prove it. If they don't send that NOD and then assess, it kind of changes the realm of what's going on. So again, not a class on NOD appeals, but this is when you would want to look for it to decide if you want to go into appeals for that specifically. Just a little heads up to everybody. My dad, Bill Nemeth, and not my dad, Steve Klitzner, are working on a class in the near future that will cover going to tax court pro se with your client. This is beyond the scope of the presentation, but it's going to be a real good class. That one I would not recommend for the beginners at heart. Of course, it's great education, but if you're going to do pro se work, to me, you better have your T's crossed and your I's dotted, because there's a very fine line, and some of the states may have a conversation with you about practicing law and not being an attorney or a United States tax court. But I'm actually looking forward to that class. That's one I've been waiting on for a while. So. Liens. All right. So now we're in the Jeff Long thing. Jeff, let me remind you, we're cut short for time. So I'm just going to touch on the basics of lien. Jeff is the lien guru, and I'm going to run through this and off we go. You should also check for liens during the CDP check. Just a good time in the process and the flow chart to check for them. Check for the liens TC code. It's a 582 lien placed on assets due to balance owed. And then you also want to see if it's been released or removed. Consult with the client to see if the lien needs to be removed or released and evaluate the options. Just remember, when they put that lien on, if I'm not mistaken, they pretty much put it to the date of whatever the current CSET is, the date they put the lien on. I'm sure there's some variations on that, but for brevity, just be advised, Jeff's got plenty of material on liens, appeals, and some of the classes. And we're going to go on to client and exam. Is client and exam or audit from the transcript? Now, here's where it gets a lot better. This gives you a lot more indicators than talking to the client. On any year where the ACET has not expired, check the transcripts for the audit exam transaction codes. 420, 424 is examination of return. 922 is the review of unreported income. If you see the audit has started, check for the following codes to see if they have ended. A 421 is the closed exam, but it can also be the 290 or 300 additional tax assessed. Sometimes the 290, 300 closes the event, and sometimes the 421 closes the event. I've seen audits that have assessed and they never closed with a 421. Remember, human beings generally enter this stuff at the IRS, and sometimes it just doesn't get done. The other thing is, I would get calls all the time about people going, the software triggered an audit and said the client's under audit and they're not under audit. Remember, the audit can show up on the transcript in upwards of 6 months or more before the audit begins, if it ever begins. Okay, and we did a whole 2-hour class on that. We'll probably do that again this year for Mitch and ASTPS. But just because you see an audit, it may not have actually begun. The flag shows up on the transcript long before the letter goes out. Continued. If your analysis shows a 290 or 300 additional tax assessed, try to determine if an audit reconsideration would benefit the client. Too many times in resolution, we look and say, oh, you got hit, the collections work is easy. I think the biggest difference between the local practitioners and the big companies, a lot of the big companies, I don't think go into the weeds as much as a local practitioner. My dad would always go in and look to do audit reconsiderations and SFR reconsiderations and those kind of things. Look at the return that assessed the tax to see if you can get it reduced. And a lot of times, by making the debt go away, it makes the collections case go that much easier. Okay, it does take a little bit more work. So one of the things you can do is go look at the return transcript for the last 4 years. Doesn't do you any good past that because they don't do return transcripts that far back. Number 2, start by interviewing the client about what happened at the audit. Call the practitioner line to see if you can get any information on the audit. As a last resort, a FOIA might be an option to find out what happened. Again, it's very little request time from your point of view to call the practitioner line, especially if you're using NQ. If you can get the audit material and find out, if the client just says, I don't know, they sent me a letter and I signed it, I would definitely look into it. If they say that they hired a local CPA or tax attorney that represented them, don't always assume that that person did a good job. There's these audit products that all these people sell, the big tax firms and all this. They're called audit protection. Most of them, all they actually do is go to the audit with you. They're not truly representing you. It should almost be called audit accompaniment, not audit representation. So just because somebody represented, there may be an opportunity to find something there. You may need to put that in your engagement letter for a little extra money and time. All right. So if needed, file an amended return and put audit reconsideration at the top if you decide that you're going to go ahead and try to do the audit reconsideration. All right, those crossouts are here for a reason. Okay, remember, audit work is different than collections. First, I had, it is difficult to make money representing clients in audit, but that didn't quite say it. It is hard not to lose money representing clients in audit. Also true. All right, finally, I went with, it is hard not to work for free representing clients in audits. Those of you out there that get $100 an hour, $300 an hour for audits, and you get the retainer up front, you're the special few. For most people, we end up getting pulled into audits very slowly. It kind of morphs into something. You feel bad for the people, but you end up doing work for free. So just keep that in mind if you ever start to go down and assist somebody with an audit. Audit representation and collection work is not the same thing. There are probably 100 to 1 collection firms over audit representation firms because there's more money in collections than in audits. Go ahead.
Roger.
Yes.
Roger, it's Larry again. Sorry to interrupt you, but while you're on this topic, I think it's really important to mention the fact that people representing the client whose tax return they prepared at an audit, according to the Office of Professional Responsibility, Karen Hawkins, they are in a position of conflict of interest. And she is adamant about it. And she said that office, now she's resigned, but there's somebody else in there. She said that office is going to start pursuing those cases. So you may want to recommend to these people to work something out with a friendly practitioner where you can put the whole case together for the client you prepared the return, but turn the records over to somebody else and let them go to the audits. Because of preparer penalties, they believe there's a conflict of interest, that you would throw your client under the bus to avoid you getting hit with preparer penalties. And that's the IRS's position on it. So I just want to bring that up. This is a good time to talk about it. It's another good reason why you can't make any money doing it.
So. Yeah, absolutely, because they are definitely the proverbial rabbit hole.
Right.
And I also recommend a separate engagement letter if you're going to go from collections to audit. Keep it separate because they are separate. Okay. Audits, while the client is in active collections, can be a challenge. Charge accordingly. If they're in collections and the audit's going on, nothing says you can't put on kind of a little extra fee on there because you're going to earn every penny of it, I assure you. All right, so those with the software, a couple of people said, definitely, I'm doing resolution work. How can I most use getting the transcripts and process into the report the fastest? This page, again, is what pretty much everybody I've ever talked to in resolution used to make by hand. The software will make it within 30 seconds of you getting IRS transcripts. It'll tell you, is the taxpayer compliant? What years were there SFRs? What years were there amendments? What years were there no returns? Are there any active liens? Have they been released? Have they been removed? Is collections active? So now you don't even have to go digging through the transcript. It will show you right here. And also, are there any active exams? This one page almost covers the entirety of the flow chart. From right here, how fast you have to work this case and you're off and running. You can also do the quick examination of, is it possibly criminal? Okay. This guy owing $221,000, we'd have a conversation about criminal. I don't think it's going criminal. We just get him set up and off we go. But I would document that I advised him and he did not want to go seek counsel. Okay. Our CSED's close. People used to never have this in their flow chart. The reason this is so important is if the CSED is in 30 days, It's much different how you're going to handle this case than if the CSED is in 7 years. Okay. Every time somebody calls me for a consultation, the first thing I say is, how close are the CSEDs? Because the CSED is the single biggest determinator of how you're going to handle this case. All right. Calculate the CSEDs and or call PPL and get them. Be aware, if you call and get the CSEDs from the IRS, tax pros should always verify the IRS CSED, since IRS IG reports 40% of CSEDs with tolling events are incorrect. I find that all the time, that IRS CSEDs are incorrect. The ones in the report are proven out to be accurate over 99% of the time. Not only that, if you have one of our CSEDs, if you call me, I will actually help you pull the Mod A, go through it. We will confirm that CSED out. Only on big cases, and if the CSED's coming up, don't call me and ask me to calculate 40 years of CSEDs just because you want to know what they are and confirm what they are. So it's free service I do. Even a non-user, I'll take a look at it and try to help out. If any of the CSEDs are close, they should be evaluated as part of your resolution strategy. I recommend at this point the bankruptcy discharge dates are evaluated. These are not available through PPL and need to be calculated. Best practice tip: I recommend advising clients on estimated bankruptcy dates and advise them to seek counsel from a bankruptcy attorney if they choose. I would note this in their file that a conversation was held discussing the bankruptcy option. Make sure they understand you are not giving legal advice unless you're an attorney or a United States tax court practitioner. The reason on the bankruptcy is you have to present your client with all options. I just went to a big bankruptcy show in Denver with NACPA, and what it turns out is this: most bankruptcy attorneys don't know that much about OICs, and most tax practitioners know about OICs and don't know about bankruptcies. I'm telling you, if you do cross, where you partner with some of these bankruptcy attorneys and get referrals for OICs, you're going to serve the client much better. These bankruptcy guys have one hammer in their box, and generally it's a bankruptcy. An OIC would probably do better 90% of the time, and they have no idea what a CSED is. And I've seen these bankruptcy attorneys drop bankruptcies within 12 months of a CSED falling off, which is kind of frustrating. But just be advised, this is the single biggest determinator of how you're going to handle this case. You call me for a consultation, this is the first thing that I ask. All right, and here are the estimated CSED dates. I don't have the report here, but we also calculate the base bankruptcy discharge dates. You can't give legal advice, but what you can say is, hey, Bob, it looks like you possibly could have this discharged in bankruptcy, this $200,000 or $300,000 debt in bankruptcy. I'm not a bankruptcy attorney, but if you're looking for a referral, I can refer you to a friend of mine or a colleague of mine that can actually go through it with you as an option. If he decides not to go, you note on his file that we discussed bankruptcy. That way, if later on he does an OIC, he defaults, and then comes back to you and says, I could have done this in bankruptcy, I'm going to sue you, you pushed me into the wrong resolution, you have it documented, your E&O is fine. He knew about the bankruptcy option and chose not to pursue it. Evaluate if returns or amendments are needed. The IRS usually defines filing compliance as the past 6 tax years. If an original return was never filed, technically they can go back forever. A substitute for return does make a year considered compliant. All right. Check to see if the IRS filed any substitute for returns on any of the past 6 years or any year with a balance due. Review the SFR year's wage and income transcripts and interview the client to see if filing an original return will help. If it's a single person with no dependents, no Schedule A stuff, it's probably not going to help, but it's worth a question. Make sure to add SFR reconsideration at the top of the return when filing. Okay. I can't tell you how many times I have seen people work a case with an SFR, and I'll ask if they went ahead and did an original return. They said, no, I do collections work. I don't do that. It's got to be at least 50%, if not 80% or higher, that a tax return done on top of an SFR for the most part is going to save people money. Okay. Returns needed continued. If no returns have been filed for one of the past 6 tax years, start gathering data from the client and wage and income transcripts immediately. The big res companies and the people that are real sharp at this, once they've engaged the client, they start working on the returns to get them compliant day one. And you start working on the financial disclosures. You don't have to work on one or the other. You have to work on both. You're going to have to get them compliant in everything but a CNC. And even then, they're going to require it a lot of the time. Okay. If original returns have been filed, review the return transcripts for the past 4 tax years to see if they were prepared correctly and if there is an opportunity for an amendment. The software we have, you can actually go into the return section. It compares the last 4 years line by line. It's very easy to spot errors. Even if you have to lay all 4 return transcripts out on the desk, it's not that difficult to look for inconsistencies and if there's an opportunity to do an amended return. If there is no tax due and the RSED has expired for a year when there is no need to do an amendment unless you want to document a correction. If the RSED's expired, it really won't do you any good to do that. So start tax returns immediately. This is a rookie mistake. The IRS will not enter a resolution unless the taxpayer is compliant. Currently not collectible is the exception. The taxpayer is not required to be in compliance, but they can ask. According to the taxpayer advocate, before the IRS will place your account in CNC status, it may ask you to file any past due tax returns. I saw the IRM preparing for this, but then I couldn't find it again. It is in the IRM that CNC does not always require compliance. Okay. Check for first-time penalty abatement. For each year with a failure to file, failure to pay, or failure to deposit, penalty check to see if any penalties have been assessed in the prior 3 tax years. Since I went long, I'm going to give you guys a little something to look out for, because if it's true, it's going to change how FTAs are done. I'm going to finish going through this and then I'll cover what it is, but it's going to be a possibility you may even be able to get refunds on old FTAs. I haven't verified it out, but I'm confident that it's going to succeed at least some of the time. So also check the prior 3 tax years to see if there are any penalty abatements. If there are no penalties or penalty abatements in the prior 3 years, then that year may qualify for FTA. To get an FTA, there needs to be an outstanding balance, or the RSED for the FTA year must not be expired. FTA will only be approved if the taxpayer is considered compliant and in an installment agreement if tax is owed. Okay. Here's FTA. The report processes it for you, but if you create your own spreadsheet, just calculate where they are. You know, if you see that the penalties have been zeroed out, it could either be in a reversal or a prior abatement. The software can detect the difference between a reversal and an abatement. A reversal is not considered. If a penalty is reversed, you can still consider it a clean year and get a first-time abatement. For example, somebody filed an identity theft return on me and I got assessed penalties for it, but then they realized it wasn't me that filed it, they would reverse everything out. That should not count against me. All right, so here's the little nugget since I took you guys long today. So I talked to my dad yesterday, and what he's been seeing is this. He's had cases with like early 2000 first-time abatements where the RSED is long expired, when you can get a refund statute expiration date. The client doesn't owe any money, and they've made a payment on a recent account within the past 2 years. So there are years that have RSED amounts available. However, it's not the year with the FTA. He's actually applied for those old FTAs and gotten refunds on the newer years where there have been payments. They will not give a refund if the payment is from a W-2 withholding. Don't know why. Don't even know if there's a glitch in the system, but it's worth trying. So if you have a client that doesn't owe anything and has a first-time abatement opportunity, let's say this 2005 first-time abatement for $16,461 is sitting down here in 05, but they don't owe any money in any other years. But let's say that, you know, they made a payment other than W-2 for $10,000 in 2016. It's worth a try. You get your client 10 grand. It's definitely a contingency fee on that. If it qualifies, let me think. Yes, you can do contingency on penalty abatements. And anytime you put 10 grand in your customer's pocket, this is big. If that is true, we will have a report in the software that will say your client potentially stands to get this for a refund. So wait to file FTA or file it now. If a penalty is still accruing, the tax pro may want to wait in order to file for the FTA. Some penalties take 5 years to accrue. If you file, and the poll question's open.
Yeah, you can keep going. I've just got to put it up though.
And if the penalty's still accruing, the tax pro may want to wait. So if these penalties are still accruing over 5 years, or if there's $3,000 of accrued penalties, the FTA won't wipe them out. FTA is only applied to assess penalties, not the accruals. The tax pro can request that collections move the accruals into assessments. Sometimes they do, sometimes they don't. All right. Represent the client. Now we're pretty much at the end. Once the analysis of the tax situation is complete, determine if you want to represent them. You don't have to take them as a client. You can always send them on their way, refer them to somebody else. It might be a case that's beyond your fit. It's up to you, but this is also a decision point for you, not only them. If the case is beyond your abilities, refer them to a qualified practitioner and sign up for more ASTPS seminars and webinars so you get good enough to handle those cases. It is possible that the client is not a good fit for your business. They may have misrepresented the facts or something else to give you pause. I have never regretted not taking a case, but I've often regretted taking one. Check out the red flags on the next slide. Client lied during the initial interview or any time thereafter. The client has defaulted on one or more resolutions. This is a big problem. What looks like a simple full pay installment agreement case can evolve into a collections nightmare. If you think you're going to be like, hey, I'm going to do a flat rate $1,500, I'm going to get you in an installment agreement, and the IRS comes back and goes, nope, they've been in 3 installment agreements, they haven't honored any of them, we're looking for other options, you are now evolved into something you do not want to be, okay? Multiple 28 and 48 and 8821s have been filed and withdrawn for the client. This is a big red flag. This may indicate they are shopping tax pros for a variety of reasons, or other tax pros have fired these people. I've got somebody that says if they see 2 prior power of attorneys on a client on the transcript, they send them on their way. Prepare engagement and get payment. This is the most important step unless you're working pro bono. Set reasonable expectations of the resolution outcome. Make sure your engagement has a clause to charge more if the case goes sideways due to uncooperative IRS employees or non-communicative clients. Make sure your engagement has a clause to end the case due to an uncooperative client or client who misrepresents themselves or the facts. Okay? If your client starts lying to you, have an out in the engagement letter. We're actually working on an engagement letter that we're going to start providing out to the users. There's 4 engagement letters, 2 for individuals, 2 for business, that I think are really good and comprehensive. We hope to make those available at the user conference after the ASTPS spring conference. And then here we are, second to last slide. Start the resolution. Best practice tip: ask the client to get their free credit report. This will assist you with financial history. Best practice tip: anytime you can get data from a third-party source like a credit report, IRS transcript, or other source, do it. The more you talk to your client, the less money you make. Questions for those that are interested in the product? THS trial will get you a 14-day trial of any of the products we have. Operators are standing by. Really, it's Laura, myself, and Chris. We'll be standing by the rest of the afternoon to answer any questions you might have. I'm going to turn it over to Larry, and just before I turn it over to Larry, I'm going to stay on after Larry with Jeff Long and answer any questions that anybody has about anything they want to ask. We are doing our user conference right after Larry's spring conference. Anybody that uses the product, it's going to be, very good to do. If you don't use the product and you come to the spring conference and come to our user conference, I will also discount you the cost of coming to the conference. So if you do Larry's spring conference and pay us $100 to come to our user conference, you can get that $100 deducted off the product plus the regular 10%. So without further ado, I'll hand it off to Larry. I apologize for going late. I really thought when I put the first flow chart in, we were going to be done in 45 minutes. I see now that we could probably go 2 hours and go a little bit deeper on it. My apologies for that. And I'll be standing by after Larry does his.
Very good. Roger, great job as usual. And appreciate you spending the time with all of the listeners here and our members and other fans of the webinars that we do. So looking forward just to telling people a couple of minutes about what's going on in the spring conference in Atlanta. And I think what you're going to find out is that this one's probably one of the most practical ones we could possibly be doing. It's a practice-oriented seminar, and its theme is, we'd like to throw a theme on the spring conference. It's called Difficult Tax Problems for Resolution Issues. And every one of the practitioners that are speaking They're people who all do the work day in and day out, and they are trying to share with you some of their lessons that they've learned, if you will, over the years. So I just got a few slides I want to go through and show you a pretty picture of downtown Atlanta there, and tell you where the hotel is. It's the Hilton Atlanta downtown. It's on Cortlandt Street in northeast in Atlanta. So all that information's on the website, so we don't have to spend a lot of time there. You will find Atlanta was selected. One of the reasons is because it's easy with the most direct flights, domestic flights into it. So to get to what I really want to tell you about is that we have Mary Beth Murphy and Darren Gillot, who are going to be at the conference and sharing their insights with you. Mary Beth Murphy is the Commissioner of the Small Business Self-Employed Division of the IRS. That should be important to any of you who do any kind of tax problem resolution. Even tax preparers should be listening to her, because their office and her what's under her aegis is the implementation and enforcement of laws, rules, regulations that we deal with every single day. SBSE handles enforced collection, examination, compliance, communications, stakeholder outreach, and so on. The best part of it is you're going to get to know her. You're going to get to ask her questions, and she'll provide answers to the best of her ability. And you'll find out, you'll get a real face on the person that is at the head of the group you're dealing with all the time. I know Mary Beth from being at liaison meetings with her and things like that. And I think she is a very capable professional who will do her best to help us. Darren Gillot has been there a couple times before. You may have met Darren in the past. He's like the #1 revenue officer in the country. All of the revenue officers are under him in the IRS, and he's constantly traveling around, meeting with revenue officers, training them, following up on problems. And we've had him give out his personal phone number to our members at a seminar. And a couple of the members told me, I called him when I couldn't get any response from a revenue officer. And in 20 minutes after I hung up the phone, I got a call from the group manager and a call from the revenue officer. So Darren really does follow through on what he says he's going to do. So both of them are going to be worthwhile being there just to hear them alone. We've also got Caroline Serrallo coming, just the nicest lady you ever want to meet, former acting district attorney for U.S. Justice. She was with the Justice Department, and she was the acting assistant attorney general for the U.S. Tax Division. Tremendous amount of experience, and she's going to talk to us about research, because when it comes to research, we often find the people who call us with consulting calls, things like that, have been somewhat stymied just because they're not sure how to look something up. You might need to find out, what are the required procedures for filing a lien or a levy when you think the IRS might have not done it correctly. She's going to go through things like that. If you're dealing with a rogue revenue officer, not only do they have the resource perhaps of calling Darren, but she's going to show you how to look up and see what this revenue officer is really allowed to do. That actually is something I did a presentation on at our recent mastermind meeting, because even the whole mastermind group needed to know that information. So you're going to get a lot of that at this Atlanta conference. The next person that I want to mention to you is probably familiar to most of you, Karen Hawkins. She was the former director of the Office of Professional Responsibility, and she's going to be talking to us about conflicts of interest. And a lot of people say, oh, I don't have to worry about that. I never have any conflicts of interest or anything else. I've got news for you. You probably have more opportunities for conflict of interest than you understand. Husband and wife could be a conflict of interest if you're representing both of them. Business owners, let's say you got two business owners and a corporation that owes back payroll taxes. Can you represent the corporation and the two owners? Can you represent one of the owners and the corporation? What is the right thing to do there? What kinds of exposure do you have when you have multiple individuals who are involved in a case in any way? They're sticky questions. And Karen's going to be there to not only speak on that, but she also takes questions and gives answers as to how to go about, dealing with those situations. And I actually have a couple of questions prepared for her that might very well be a new insight for you, even when you're doing a tax return. Is there potential that you have a conflict of interest because you have a joint tax return, a husband and wife? And sometimes we don't look into things far enough. And it could be that there is a conflict there, even though everything seems to be fine. You're just doing a routine tax return. So you want to tune into that one. It's worthwhile. Then we have our perennial favorite, the godfather of tax problem resolution in many ways, is Robert McKenzie. Bob is an attorney with Arnstein and Lair. And sorry, his firm name's changed. I should change that. I need to change that in my head is what I'm saying. But Bob has been practicing before the Internal Revenue Service and representing taxpayers for many, many, many years. He's going to talk on offer and compromise, innocent spouse, and so on and so forth, how to deal with some of the tough problems that you run into when you're doing an offer, and what solutions he's been able to apply to these cases. So it's not just a case of pointing out what the problem areas are. You may know those, but he's also going to give you some of the insights that are needed, and he's going to do the same thing in the area of innocent spouse relief. So Bob's going to cover two different topics, and he's going to try and give you not only the questions, but the answers in their area. And Bob is a typical favorite of all of our audiences. Cheryl Travato runs a course for the practice before the U.S. tax court. And Cheryl understands that this isn't for everybody. She's probably got the most successful course that you can take in becoming qualified for U.S. tax court. She realizes it's not for everybody. She's going to present on why it might be for you, why it might not be for you, and when those situations would apply. And it's something that I think a lot of us need to know. And she'll also share with you what you might have to invest in getting it done, the time it takes to do it, the cost for the training course, and all of the rest of that. She's going to make part of her presentation, so she'll try and answer all of your questions. And Jeff, are you still there? Is Jeff Long still there?
Yes, I am. Yeah.
Hey, Jeff, you know what? I'm gonna let you tell him what this good-looking guy is going to be talking about when he's there. Because as long as we got you on the line, I'll let you toot your own horn in a minute.
Right, I appreciate it. So I'm kind of picking up from the spring conference that I spoke at ASTPS last year, and we're going to provide at least 4 good case studies that show some of the things that I think are a little bit unbelievable now, just based on the manning shortfalls of the IRS and the time constraints that they have, and how we can really use that to be very aggressive and wonderful advocates for our clients. So a few of the things I'm going to talk about, I'm just a huge believer in the Form 911 from Taxpayer Advocates. I'm going to go into that, renew the numbers from last year's conference, and really probably that could be a whole course, the Form 911, but I really want to hammer home to everyone in attendance that the 911 is not used as often as it should be, and I use it on many cases. I'm under the opinion now, after working with Hansley Cook, a good friend of mine who is a very capable tax resolutionist, that partial payment installment agreements are now the new OIC. We're getting a much better deal. Just a really wonderful way to, I used to think about OIC first, and now I think about OIC second, and I'm going to show you why. I'm going to go into kind of a new thing, at least to me. I'm a former IRS tax collector, and I could never do a business currently not collectible. And I've won currently not collectible on a very large business case. In the old days, we just levied them out of existence, and that was we created an involuntary bankruptcy. But there's such a thing as an in business currently not collectible. Now we'll go into that. Another thing that I'll touch on is the problem of under installment agreements, when your client owes the State Department of Revenue and they've entered into those are normally pretty bad, very quickly repaid installment agreements from the Department of Revenue for a state, and then the IRS says, no, we're going to use a pro rata thing, that the state was owed 1/10 of what the IRS is owed, therefore we're only going to allow you 1/10. And of course, your client's got a $2,500 monthly payment to the state, and IRS now wants to allow that at $100. I'm going to tell you how to defeat that. And then this just perennial problem that we all have for offers and compromise, currently not collectibles, and IAs, where the IRS just wants to use these national standards. They just want to just use the shortcut that Congress says specifically they will not use shortcuts. I'm going to show you how that one size fits all allowable standard can be defeated. And in a way, if you think about it, that's really what our client has hired us to do. If the client was just going to have a one size fits all standard, they don't really need us. We need to be a lot more aggressive. And I'm going to show you IRM sites and probably a couple of court cases that allow you to tell the IRS, you're not using standards for my client. That's in a nutshell. That's what I'll be presenting. And I've only got 2 hours. They have a wonderful group of people, as Larry has covered. So I'm sure all of these, but I'll be there in attendance, and I'll be able to answer questions of anybody throughout the entire conference. So if you have any,
Great.
bring them, and I'll be happy to answer.
Well, thanks, Jeff. We appreciate that. And I got want to talk about 2 more people who will be there to round out that great group of people. We also want to mention that Claudia Hill will be there, and Claudia is going to be covering. By the way, she happens to be the editor of the magazine that many of you should be reading if you're going to do tax resolution work, and that's Tax Practice and Procedure. And she's the editor of the magazine as well as being a longtime taxpayer representative, and she's going to discuss a really current topic about you've been breached. Now what? And what she's talking about is if your system gets breached, let's face it, we have everything an identity thief wants. I mean, we not only have their social security number and their bank accounts and their address, we've got their children's social security numbers, et cetera, et cetera. I mean, and the funny thing of it is, it's so difficult to protect yourself. You've got to do everything possible because the identity thieves have zeroed in on tax and accounting officers as being the lowest hanging fruit. They love it. And so often our offices are not all that well protected. In my own office, we've invested approximately $50,000 in protection of our systems in the last year. And it's just because it is one of the most difficult areas for us to deal with to protect yourself. If they can breach the Pentagon and the IRS and everybody else, don't think you're so special. But you've got to do your best to make it hard for them and to protect yourself and to know what to do if it does happen to you. That's critically important. And Claudia is going to cover all of those. And hand in hand with Claudia's approach to it is going to be David Wolf, who is a computer security expert. And in fact, the gentleman who installed the whole system in our office for us in this last year. And he's going to, cover all those things, all the types of firewalls, password protection, double authentication, system redundancies, malware, phishing, encryption, all those things that, are just ugly words that we don't want to hear about, we don't want to think about, but we have got to do that. So we thought it was critically important to put these things on the agenda this year and make sure that our attendees are aware of things that they should do, they need to do, and what they can do. What I want to mention, by the way, right now, there are only 25 seats left. And it's not a case of us trying to be exclusive. It's a case of there's only so many seats in the room, and all but 25 of them are taken right now and reserved. So June 7th, 8th, and 9th in Atlanta. On the 7th and 8th, by the way, there will be a boot camp. So if you have someone you want to train, or if you come to the boot camp, you can sit in on the 3rd day in the meeting room for the spring conference and hear the 3rd day speakers. So we think it's a very nice benefit for anybody that goes to the boot camp. If you bring it, let's say you have a staff person, you might bring them to go to the boot camp if you've already been there and you come to the spring conference at the same time. So you're getting 2 people trained at the same time. So don't want to spend all day long. I know you've all stuck around longer than what we anticipated doing. So I'm just going to say that if you want to stick around after our conference is over on the 7th, 8th, and 9th, then on Sunday following our conference, that's when Roger, who just finished presenting to you, is going to do a tax help software users conference. And he's doing it in the same hotel right there, so you don't have to go anywhere else. You just stay a little bit of time, and you'll get a lot of insight into what Roger does and a little more of what he's been talking about today, probably. So other than that, Mitchell, do you have anything to close with? I don't want to keep him any longer than we have to.
Well, I don't know if Roger wants to talk a little bit more about his conference.
Oh, yeah, sure. He's more than welcome to learn that. I covered what I want, so Roger, if you're there and you want to do it, you do it, and I'll shut myself up again.
No, yeah, I think you've pretty much covered it. Ours is just going to be one day. We're going to, show existing users best way to set the system up, let it request the transcripts, how to track audits in advance. But we're going to show it in a way from start to finish. If you're not a user of the software, you can get a 4-week trial if you come to the user conference. We'll set you up with it. You try it for 4 weeks. In essence, you'll learn how to do everything you learned in Larry's boot camp, but you'll learn to do it with the automation of the software. And we've got some interesting things this year. One of them is we're the only one out there that lets you start importing things into the 433, like wage and income transcripts. So I kept harping on everybody about get data from third-party points. You can get all the employers from the wage and income transcript. So instead of writing all your employers' addresses in your 433s, we're going to let you import them from the wage and income transcript. Property. We now have the ability for you to import the 1098 statement, sync it with Zillow, and get all that information imported straight into the 433. We're actively working on something called an asset report. It's the same report the IRS uses to import into the 433. Within the next 12 to 18 months, our goal is to have 75% of the 433 completed through an automated process versus having to ask the client. You'll still have to have the client verify all the data, but our goal is to automate just about everything except unreported income and expenses on the form itself. In other words, within the first 48 hours of that person walking in your door, you'd have the ability to almost have the 433 completed out. So, and also I wanted to be available if anybody had any questions. I've had a couple emails already about the first time penalty abatement, what I said about being able to get the refund. So without further ado, unless anybody else has anything else, I'll open it up to questions. And if anybody wants to know more about that penalty issue, let me know.
Yeah, if you want to answer a couple questions, you can definitely do that. I saw in here a few times they were asking about exactly what you were talking about, so I don't know if you want to go over that again.
Yeah, so I'll start off with that, and I have my mic up a little bit, so the volume's probably better now. So what my dad told me last night is he does a lot of first-time abatement. So if you have an early first-time abatement, and matter of fact, Mitch, is there any way you can give me back the screen, and I'll put up a screen here that'll help illustrate
yeah, definitely.
Let me see which one of these is. There it is. All right, so from current slide. All right, so can everybody see it? Yep, there it is. All right, so what it basically says is this. So prior to the big changes, I think back in November when they started getting real picky with first-time abatement and all this, you could go back and get a first-time abatement in a really old year, but what they would do is they would only apply it if you had a tax debt in an earlier year. So let's say in 2016, I owe $40,000. All right. And I go back to 2002 and get a $20,000 first time penalty abatement. They would apply it to my oldest debt. Okay. So what's happened recently, or at least this is the theory my dad's working off of, is he told me he's done several of these recently. We don't know if it's a thing yet. I haven't seen enough of them, but it's definitely worth a try. So these clients have not owed any money, but they've made payments on any tax year within the past 2 years. A refund statute expiration date says you're subject to be able to get a refund if you have some reason to get a refund. That's that, you have so long after the return is filed and the assessment's made, and then 2 years after any payment. Okay. Without going into that too deep, any payment made on any tax year, if the client doesn't owe anything and you go back to an old year and get a first time abatement, say for $5,000, you can get that first time abatement as a refund up to and including any payments you've made in the past 2 years or anything else that falls under the RSED, with the exception of W-2 withholding. For some reason, they're not considering W-2 withholding as a payment to get refunded. Not sure why, but that's just what's out there. We're starting to investigate it. It just came to my attention last night. I figured it's enough to put it out there. It may be one of those myths that it's not really true, but the upside is find a client that's got it. If they're not going to do anything with the FTA, you're not going to burn the FTA. If they just say, hey, there's nothing we can apply it to, we're not going to go ahead and process this. It didn't burn your one-time FTA. But if it works, I know just on a sample bit of data that I looked for some historical transcripts I have from when I was doing representation, there's probably a third of the clients out there that would now qualify to get a refund if they can meet the payments within the past 2 years. So, and by that, I would just start doing less withholding for the next tax year, wait for my tax bill to be due, and make a payment with a tax return. That would qualify. So you could actually do future tax planning in order to get the FTA refunded to you if this is true. So if it's true, plan on us doing at least a quick seminar, maybe an hour. This one may be an off the books one where we just push it out when it's available. What we're trying to do is at least one presentation a month with Mitch. So if that one turns out to be where it's something, that potentially could be a moneymaker for everybody involved. So that's all the information I have on it right now. If you have somebody that doesn't owe any money, has made a payment within the past 2 years, other than withholding, try an old FTA, see if it works. So if you got the software, you can find it from the main dashboard, see if anybody qualifies for an old one, and just apply for one. I'm interested to hear what the outcome is, and we'll go from there. Are there any other questions?
Yeah, so let's just do maybe one or two more. I know it's getting late here. Vanessa had asked, is there any way to find out if multiple 2848s have been filed?
If you're talking about it, historically, if there's it's on the tax return. It's yeah, I can get you an answer here in just a second. It's hold on here. And for anybody calling, Laura and Chris should be available. If they're not, leave them a message and they will call you right back. And Control F, appointed. This is a list of all that you're looking for, the 960 and the 961. Appointed representative in 961. Now, if she's asking, can you tell if multiple people are currently under POA, 99.9% of the time, if you drop a POA, it's going to overwrite any previous POAs unless you attach the previous POA and off. But a 2848 doesn't trump an 8821, and an 8821 doesn't trump a 2848. But the best way to find by looking on the transcripts of how many prior POAs there are, if I understand the question, you're looking for how many 960s there are. Hopefully that answered that.
Okay. And then we had a couple people who wanted you to recap your offer that you were making if they come to the user conference.
Gotcha. All right. So if you're not a user and you're going to the boot camp, or you just come straight to the user conference, if you attend the boot camp or the spring conference, it's only $100 to sign up for our user conference. It's going to be 6 hours of CPEs. And so for the new folks, click over here. So what it is this. Obviously, if you're not using the product, you're thinking, why would I want to go to a user conference? You may be thinking, I want to see how it benefits me, plus I'll still get the 6 hours. So what we'll do is we'll sign you up for a 4-week trial here at the conference, so you can try any of the products we have. The executive with the resolution package would probably be the one that fits most people for doing tax resolution. Not only will you get the 10% ASTPS discount for coming to the user conference, but you would also get the $100 off that you paid us to come to the conference. I didn't know how else to make an incentive for somebody that doesn't use the product to actually come and learn about it. So I think that's a fair one. I would be willing to basically comp back out. And one thing I'll tell you about our user conference, there's other products out there that'll do user conferences. Our goal was not to make money on it. The $100 and the $150 sign up fee, if you're just doing just our conference and not the ASTPS, merely is paying for the room and the coffee. It's not paying for our time. We're not paying any salaries out of it. And anything that I estimate will be over and coming in will apply to the food budget that we're going to have. So we may have a little better snacks if it starts to rotate up and be profitable. We got to figure out how many people we're going to have. According to what Mitch says they have and what we've had directly, should be right at 50 or just over 50 people. And I've got a lot of people locally in Atlanta, because that's where I'm from, that have advised they're going to be coming and haven't signed up yet. We can accommodate 100. I always thought we'd be between 50 and 75. That's kind of where it's at. If you're on the fence about, there's a couple products out there that do this now. currently, out of the top 10 resolution firms by size that arguably do most of the OICs and, a lot of resolution packages, ours is currently the only product they're using. Not everybody's using our 433 package, but everybody's using transcripts. And about a third of them are using our 433s, and the other 6, 7 are evaluating the 433s currently to see if it's going to be a good fit for them. The ones that don't use us, funny enough, for the most part, are doing them by hand because they say that's just how they've been doing them forever and it's quicker for their staff to do. So our goal in doing the 433s is we want to be the fastest, most accurate 433 out there. If the IRS will turn on to where we can get IRS transcripts instantly, I think you'll see in the next 12 months, you would be able to basically have a client walk in the door, and by the time you can download asset reports and credit reports and everything else, you'll have most of the 433 financial statement done on the spot. You'll have the case mapped out. So that little flow chart we have, literally our goal would be to have it all done within 90 minutes of the client walking in the door, including a good part of the financials up. So if they walk in the door, you get most of the financials done. You could just plug the national standards in just as a quick plug-in until you get the actual expenses, and that's going to tell you real close to what their final resolution is going to be. And we're excited about that. So
cool. And yeah, I just wanted to bring one more thing up. So if you're still in here, we still have a few hundred people in here. So I know a lot of you guys are new to tax resolution. So if this is something, if you've been hanging around, you've watched a couple webinars, and this is something that you're interested in, giving a shot. So what you can do, and if you're interested in tax help software, what you could do is you could go to the boot camp, our 2-day technical boot camp, where we cover everything you need to know to get started doing the resolution work. So you can go to that boot camp for 2 days. So it'll be Thursday and Friday. Super conference on Saturday, which will go till I think about 3 o'clock, and you'll get all the credits for that. And then you could stay for Roger's user conference. So total, you would get probably 28 hours of continuing education over the 4 days. Plus, you have obviously really good base for your tax resolution education, as well as you'd learn quite a bit about how to use one of the best tools available, as far as tax resolution work goes, and you'd be really all set to get started, working on the cases. So, it's a great opportunity.
I was going to say, Mitch, if you come and do the boot camp, the Saturday with the advanced stuff, the user conference, do a trial of the software within a week, unless it's one of the 10% complicated cases that you get in collections, you could be working collections cases confidently within 10 days. And that's the time it would take to actually get some cases. You're going to find that it's pretty straightforward. Collections work is straightforward. There's always the exceptions out there. There's always it's the IRS. 90% of it's easy, and 10% of it, is 90% of your work. But for the most part, you're going to be negotiating installment agreements, partial pay installment agreements. And I can reiterate what Jeff said. We've been starting to get feedback from our users that the partial pay installment agreement, which is basically just an extended OIC, has been the better deal for people out there lately. So.
Cool. Yeah. I mean, the whole thing with all, tax resolution is, if you really want to get started in it, it's actually, if you compare it to a lot of other, businesses that you might try to get into, really you could go to our boot camp, you could get Roger software, you could get a membership, for, less than $2,000. And the average tax resolution case, we run a CPA firm in Buffalo, New York, so along with ASTPS. And I can honestly tell you that our average case is between $3,000 and $5,000. So we're a long way away from New York City. Buffalo is a very blue collar area. So, if we can do it here, you should be able to do it just about anywhere. And those are our honest average case fees. So, for a little bit of time, and obviously there's a learning curve, but there's a lot of support out there. I mean, I know Roger helps users. We help through our membership. We have case consultations, things like that. If you come to the boot camp, we actually give you a consultation as well. So yeah, I mean, and then plus we do our monthly trainings and things like that. There's a lot of, great educational resources that we can provide. And, Roger's on top of all the updates and everything. I know he gets anytime there's any changes, they update their software like immediately. It's kind of crazy how fast they do it. And they're really on top of everything. So, it's just making the jump and deciding that this is what you want to do. And there's the resources there to make you successful.
If you get stuck over your head, that's kind of the fear I hear from new people. If you get a case that's over your head, if you call me, I will send you a list of people I know locally, and I'll tell you, hey, I know this guy's a good guy. Maybe I've never been to Boise, Idaho. I might say, here's 4 people we have in Boise, Idaho that are willing to help you. I'll tell you if I know them. I'll tell you if they're just a user. I don't get any money from it. But don't worry about getting in over your head, because we can always get you to somebody that can help you. Just don't wait too long. That's kind of, that's where everything. Don't show up the day going, hey, there's a demand letter for today at 5 o'clock. Who do you have in, Northern California? We don't work like that.
Yeah.
Nobody's going to jump in at the last minute.
Absolutely. Yeah, I mean, we have over 1,000 members too. We have members in every state: Hawaii, Canada, I think Puerto Rico. So I mean, there's going to be somebody at least in your state, especially if you have state issues or something, that can help you. We're really, if you go to any of our seminars, you'll find that we're really community oriented, and we always do. We added networking events that are free for all of our attendees to come to now. So it's all about developing your referral network, your your support network, and there's a lot of people out there that are helping, that are here and willing to help you. That's what we do all day long. So yeah. And so someone just asked, will THS be at the boot camp? So that's a good question. So yeah, Roger, I believe either you or your dad or somebody will be at each of our boot camps this year.
Yeah,
correct?
we're not gonna be in Buffalo. We've got a conflict for Jacksonville.
Oh man, you don't want to come to Buffalo?
But you guys said we're not invited because there's no room.
Yeah, that one's in our conference room. We don't have a lot of space for that one. So
yeah, so
most people don't want to.
Yeah, my dad will be in Denver because I got another overlap on a show. But yeah, my dad, who speaks for ASTPS as well, he will be there in Denver.
Yeah. But anyway, all right, I think that's enough from us. So if you guys have any questions, if you have any questions about your CPE or anything, like I said, we're going to send out the certificates on Friday, but don't call Roger or THS because they don't have anything to do with it. Just give me a call or give our office a call and we'll figure it out for you if you don't get the certificates or anything. But yeah, if you have any questions about the membership or THS, give Roger and Laura a call over there. If you have a question about our boot camp, spring conference, I know I can hear Carolyn in the other room. She's already registered like 4 people since 3:20. So we only have a few spots left in that. So if you just call, get organized, get registered for whatever you need to do, and we'll see you in a couple of weeks. I think our next webinar is going to be May 15th, I think, or something like that. So you'll get an email for that. But yeah, thank you guys all for coming. Thank you, Roger. Thank you, Jeff.
Sure.
And we'll see you all soon.
Have a good day, everybody. Bye-bye.
Bye.
Take care.